We have filed an emergency petition with the Supreme Court of the United States to take away the mandate banning firearm sales on state-owned property. This is B&L Productions v. Newsom. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are going one step further with the B&L Productions case, filing the application to the Supreme Court, and here to talk us through it, she's the one who did the application. That is a partner from Michelle & Associates, Anna Barvier. Anna, thank you very much for being with us.
Well, thank you for having me.
Absolutely. And guys, before we get into this today, please, we are trying to get as much of this kind of content out as we possibly can. Please be sure to like, share, and subscribe to these videos, especially that like button these days. It really helps the algorithms get this information out there. It's coming from the attorneys who are actually putting in the work on these cases. We want to make sure that everybody's up to date. So, Anna, let's, before jumping right into the application, maybe it's a good idea. Let's get a whole 360-degree perspective on this. This isn't a battle that started simply with litigation. This has been pushed at the fair boards for a long time. This is something that I've personally done. I remember going to fair board meetings, fighting the Brady and the Moms Demand Action groups about their appeals to fair boards, trying to take away the contracts for gun shows. That didn't work. Our argumentation at that level was effective to where they kept the majority of the fairgrounds kept the contracts that they have. But what that turned into was their appeal to Sacramento and the legislature to pass laws that effectively ban shows on state-owned property. What the laws actually do, maybe we can get into a little bit, banning the sale of firearms. But can you go ahead, as far as the litigation is concerned, give us the build up to where we are right now filing with SCOTUS on these cases?
Of course. As you mentioned, this case started, far before where we are today with the statewide ban on sales of firearms and ammunition on state-owned property. I got it first involved with this litigation when we sued the Del Mar Fair Board in, I think it was 2018, 2019. They initiated a moratorium on all gun shows at the Del Mar Fairgrounds. We promptly sued on behalf of B&L Productions and a number of their vendors, as well as CRPA and other Second Amendment civil rights groups. And we won immediately. We immediately got a motion for preliminary injunction granted, and the court basically suggested we settle. And we did, and the Fair Board overturned the moratorium, and we won attorney's fees and damages for the client. After that happened, the state got wise and passed the first of three bills, one banning the sale or contracting for the sale of firearms and ammunition at the Del Mar Fairground. That passed, and we brought a lawsuit in the Southern District. About a year later, Min brought an identical bill, or virtually identical bill, that bans the same conduct at the OC Fair and Event Center, and followed that up with a third bill that expanded the restriction all over the state to all state-owned properties. We brought a lawsuit on that and immediately followed with a motion for preliminary injunction. We lost in the Southern District on the state's motion to dismiss, but we won our motion for preliminary injunction in the Central District. We appealed the loss of the motion to dismiss to the Ninth Circuit, and the state appealed their loss of the MPI to the Ninth Circuit. Cases were consolidated for argument and for decision. We had a really tough panel, and we lost 3-0 before the Ninth Circuit panel. We brought a petition for en banc review, and that was denied. After that, we asked the court, the panel, to do a thing called staying the mandate. That way, the case would not go immediately back down to the two district courts, and our motion for preliminary injunction could stay in effect until we had time to ask the Supreme Court to review the case. And that's where we are now.
Well, and a couple, so the opinions or the decisions are those decisions. I've gotten a lot of questions. I'm just wondering if you can bring some clarity to this, because the opinion from the Ninth Circuit effectively overturning the preliminary injunction that we had, stopping this law from being enforced, which allowed gun shows to continue. I got a lot of questions because we get this opinion effectively saying, okay, you don't have the preliminary injunction anymore. How is it that gun shows are still going on?
That is a really good question because the case is quite confusing. And here, I think there's two reasons that you're going to still see gun shows going on, or you, excuse me, we continued to see gun shows being contracted for and being scheduled and taking place after the Ninth Circuit's decision came down in June. Because I had mentioned it earlier, the thing called the mandate does not issue for a certain amount of time after a Ninth Circuit decision comes down. The number of days differs if you're seeking for if you're not seeking rehearing, it's like 21 days after the opinion. If you do seek rehearing, you get time after the rehearing is denied. Whatever, you have a different number of days. Once that time has expired, a thing called the mandate issues from the appellate court, and it mandates that the district court follow the rule of the opinion. Whatever the opinion said that they're supposed to do. In our central district case, it was to vacate the preliminary injunction. In the other case, in the central southern district case, the mandate issued and basically says your final judgment on the motion to dismiss is good to go. The case is done, and then they can completely clear out the case. That's why, because we had gone through and sought a petition for rehearing, and then we sought to stay the mandate, all of those things hit pause on the issuance of the mandate and the requirement that the district courts move forward with and make final the Ninth Circuit opinions decision, right? The other reason, and this is very specific to this case, that you're going to continue to see events called gun shows still happening is because while we call it a gun show ban, these three laws we call a gun show ban, we call it that because it's the practical effect, right? The event that we all know and love as a gun show is a place where people come together, they do lots of things, but an important part of it is commercial activity surrounding firearms and ammunition and parts and things that have to do with owning and using guns, right? If you take away that economic linchpin, that the sale of firearms and ammunition, people don't come. And if people don't come, are vendors going to go and show, do gun show and tell? They're not going to. So the events are going to practically stop happening. They're going to wither up and die. And that was Sacramento's very purpose behind the law. They said it repeatedly is what we're trying to do, but they were doing it in a way because they knew they couldn't ban gun shows because that's a First Amendment violation. Ninth Circuit law is clear about that. They knew they couldn't do that. So they're like, well, we'll do it. We'll ban it this way. We'll make it their fault that the gun show is banned, right? We'll make it the producer or the vendor's fault. And so because the law doesn't actually ban gun show events, it only bans sales, right? You might still see producers and vendors who are willing to host events that look like gun shows, but they're going to be really weird because you're not going to be able to take ammo home, right? You're not sure how much you can do with regard to a sale of a firearm. So the case it leaves us in a real weird limbo where we don't know what conduct is okay. And so some producers may be willing to have events and others may not.
So it sounds like just the way California likes to play it, a little bit ambiguous as to what can or can't be done. But it sounds like what you're saying is we might still see the regular gun show promoters still holding shows. I mean, if anything, maybe just to stay prevalent within the community, as they would expect, maybe we can get this overturned and the sale of firearms can continue in the future. But more importantly, what it sounds like is there's a huge difference between an opinion and the mandate of that opinion. And I guess what we continue to see the contracting of gun shows and gun shows going on state-owned property, even after we saw that opinion, it was because the mandate hadn't taken effect. But now the mandate has taken effect, and we have filed an application with the Supreme Court. Let's talk about the Supreme Court here for a second. Maybe you can inform me a little bit. So we're putting in this application, but is the Supreme Court even in session right now?
The Official Supreme Court session begins on the first Monday of October. So no, they're not quite back in session, but that doesn't mean that they're not working, right? So even in this throughout the summer, when they're not officially in session, hearing oral arguments or writing decisions, they are hearing emergency applications, they are hearing cert petitions, briefing is happening. So all that continues to happen even when they're not sitting.
Okay, so that makes sense. So even though the typical session that we see the Supreme Court of them having their conferences, hearing oral arguments, seeing stuff like this, they get all year round. That's normal practice. So this isn't really anything out of the ordinary. Let's talk about that application for a second. And Jacob, if you could actually pull this up, this is from the application that we put in there, and it's under the section of reasons for granting the application to the Supreme Court. It reads like this: because the Ninth Circuit decision disposes of constitutional questions of exceptional importance, and it does so in a way that so openly defies this court's clear commands, there is at least a reasonable probability that 4 justices will consider the issues sufficiently meritorious to grant certiorari. Moreover, because the decision conflicts with the controlling precedents and misstates the rule of law, there is more than fair prospect that applicants will prevail. And absent the relief applicants seek here, they will suffer irreparable harm, including the violation of their rights under the First Amendment, Second Amendment, and Equal Protections Clause until this case is decided. So, I mean, here we are. We got First Amendment, Second Amendment, equal protection. These are obviously strong arguments. We feel they're strong arguments. We got a motion for preliminary injunction at the Central District Court. We're also looking at what we would consider a favorable Supreme Court. Does that bring any solace, bringing this as an application to SCOTUS when we have what looks like a two-way friendly Supreme Court?
I have a lot of faith in this court to accept this application, and our cert petition at the end of the day, right? Because for a lot of the reasons you mentioned, these are important fundamental constitutional rights at issue, and we tend to have what we think is a favorable court. But as I think you and your viewership understand, emergency applications to the Supreme Court and even cert petitions to the Supreme Court that's extraordinary relief, and the court only can take a few every year. So barring, putting aside that it's already an uphill climb to get our arguments accepted, I really like this case because we have kind of a 1-2 punch going. With the First Amendment, we have analyses under the commercial speech doctrine that have been questioned by sitting justices repeatedly for the last 20 or 30 years. Some of the sitting justices have questioned whether their precedents and the authority for the commercial speech doctrine and that sort of speech being treated differently from other sorts of speech is really the right track. And I love that this case really shows, because of the way politicians in Sacramento wrote the bill, it really shows how it's almost impossible to divorce the commercial speech aspects of gun shows from the political and ideological speech. And I really love that that angle, and I think members of the Supreme Court will like that as well. Then you have the other punch of the Second Amendment, and what we see the Ninth Circuit doing was looking at two appeals of a case we won one and we lost the other. Two judges had found quite opposite, made quite opposite rulings. And you had them affirm the decision from the Southern District that basically stated we had no claim because we could not establish that we had a meaningful constraint on Second Amendment rights because we couldn't prove, or we didn't allege, that we couldn't buy guns absolutely anywhere else. And we all know that that is a complete fabrication that comes nowhere from Bruin or any of its the Supreme Court's previous Second Amendment decisions. They have to look at historical analogs, and the Ninth Circuit and the Southern District refused to do so because we didn't allege that our folks couldn't buy guns anywhere else. And that is such open defiance of the court's recent decision in Bruin that I have. And maybe this is just like that little glimmer of hope that I still have as a lawyer after doing this for so many years. But I have to believe that our Supreme Court won't stand for lower courts continuing to be in such defiance.
Especially given that Bruin is such a recent decision. You would think that they would be putting some some hard effort into understanding what it is and applying it appropriately. Well, we have what we think is a strong argument. We have what we think is a strong Supreme Court. What are your final thoughts going forward? I know it doesn't always produce an answer, but I got to ask, any expected time frame for this, just as far as getting a response back on it? Is there a boundary with which the Supreme Court has to work within to give us an answer of whether or not they're going to take it?
Emergency applications, I mean, they are just that, they are emergency, and so they do usually decide them pretty quickly. Though I think we'll tend to know a little more. We'll know really quickly if the court decides not to even get an answer, responsive brief from the state. We'll know that that's probably they're not going to accept it, and we'll know pretty quickly, I think, on that. If that happens, if the court asks for a response, it could be a little longer, but we're thinking, my co-counsel Dawn with Second Amendment Foundation and I are thinking we will probably know mid to late October. I'm hopeful.
Well, that's not too far away. Definitely something to look forward to. And then I guess my last question to you is, if the Supreme Court decides not to accept this, you mentioned that there were two cases that were kind of consolidated in here. One of them's gone to judgment, but the other one hasn't. So what would the next steps be if the Supreme Court were to decide not to take this in the one that hasn't gone to judgment yet?
Oh, that's funny you ask. Because the mandate did issue, this court, unlike our court in junior sports magazines, jumped very quickly to enforce the court's mandate, as it should have, even though we lost. It acted really quickly. So it's issued an order for us to work together with opposing counsel to submit a joint status report by the 10th. Or the 11th, the 10th or the 11th, just to let the court know where the case stands right now. And then we will be providing the court with our proposed pre-trial and trial calendar. Excuse me. The court, then we have a CMC case management conference in the court in Santa Ana on 10/25. And we'll get a case calendar, like a roadmap for where the case is going. But I suspect because of the way the decision came down from the 9th, the state's probably going to file a motion to dismiss or a motion for summary judgment rather quickly.
Well, I guess things to look forward to on a couple different levels there with the same case. I like to be an optimist, so we're definitely going to be watching the Supreme Court application, but having the other level to fall back on, definitely something that we're going to keep an eye on. Anna, I know you're busy. I want to thank you very much for coming on and giving us this explanation and walking us through this. I really appreciate it.
Of course, I always enjoy being here.
Absolutely. Thank you again. And guys, if you like content like this, want to continue to get it from the people who are taking the action in the courts, please be sure to like, share, and subscribe to this video. You might keep hearing these people say that we got tough panels. We're not living under the last presidential administration anymore. While the Ninth Circuit may have gotten to 50-50 conservative judges since the previous administration has gotten into office, it has started to sway the other way. I say this to you because we have elections coming up. We can do something about it by casting our vote. Please be sure to go forward with the Second Amendment as a priority when you go to vote. Thanks again, guys, and we'll see you on the next one.